Let me tell you about an amazing family we got to represent all the way up until a trial. It's a car wreck case and it involves a deer and blaming a deer uh, that ultimately led to my client getting hit head on. I was a young plaintiff's lawyer. I got to try the case with an exceptional mentor friend who is also a partner on the case, and we got to take this case all the way to trial after giving the insurance company many, many, many times to settle the case before we ever got to trial. Let me tell you what happened. Duluth, Georgia, Gwinnett County, there was an amazing woman who was driving home to go see her husband. She was on the road, driving safe, rounding a curve, and as she rounded that curve, all of a sudden, another vehicle, two-lane highway, comes into her lane and strikes her head on collision. Cars are totaled. Our client had horrible injuries, multiple surgeries, neck, knee, other surgeries. And that car that came into her lane was actually a corporate defendant, meaning the person that was driving that car, it was a nice car, was in the lane of travel, struck her head on as he was taking that car to be delivered to one of his clients. Backing up, let me back up for a second. When that corporate defendant who was driving the car in the other person's lane, he said that he was not at fault for driving into our client's lane. How could he ever say that? Well, as he was rounding the curve in the opposite direction, he cited that there was a deer crossing the road, Bambi, literally crossing the road, which caused him to swerve into our client's lane, striking her head on. We get the case. We understand the facts and the issues that are in the case. We take the driver's deposition. We also take another witness deposition who also saw this deer. And it turns out the deer wasn't really an issue at all. There was a deer that may have been up ahead of the driver that was at fault that crossed along the highway, or the two-lane highway, and had already made its path back into the forest. However, this corporate defendant didn't want to take the responsibility, and so he blamed a deer after hitting our client head on. Gave the insurance company multiple opportunities to settle the case. Please settle the case for this number. Please settle the case for this number. No, we're not going to settle the case. We don't think our driver was at fault. And so what happens in that case? We got to take the case to trial. We don't want to take every case to trial, but the cases that will not settle, we take to trial because we firmly believe in our clients, their position, and in this case, we most certainly did. I'll never forget, we had that corporate defendant driver on the stand, and after 4 days of ton of testimony, officer, witness, medical provider testimony, doctors, experts that talked about our client's injuries. And the corporate defendant driver got on the stand, and I had the opportunity to cross-examine him, meaning I got to ask him all the questions about that day, the facts, what he was looking at, the things that he did, the things that he didn't do that gave rise to this severe head-on collision with my client. And so we got into it, and I started questioning him about the facts of the case, what he was doing, what he was looking at, where the deer was. And his story became so implausible that you could almost see in the jury's face that this guy is blaming a deer for not stopping his car in time. And instead he elected, because he was in a high-powered car with a great engine, to go around into my client's lane, causing this horrific collision. And so I asked him on the stand, after all the evidence had presented, showing that he was at fault, I said, will you now say before God, man, all of these people, based on all the evidence that we've been presented, that you were at fault? Will you now accept responsibility for this wreck? And he said, no. And you could hear a pin drop. And also you could see the faces of the jury that were frustrated. They were angry. And so I sat down. That was all I needed. I sat down, questions over. It was so clear that he wouldn't accept the right thing in that case. So I sat down, and then we have the opportunity to give closing arguments. In Georgia, if the defense presents any evidence in the trial, we get to have last close, meaning the plaintiff, the people that I represent, I get to have the first closing argument. Defense goes. If they put up evidence, then we get to go back up. We get to go back up. And in this case, I had the opportunity to give the opening close. The partner on the case gave the final close, did a phenomenal job. But in my close, this is what I said. I said, at the time, I have a fourth grader. We had a new puppy. And I said, there is no mistake that this corporate defendant is doing anything different than my fourth grader. What do I mean by that? Well, with our new puppy and my fourth grader, we had some reports at school that his homework was going missing. And he, I kid you not, had the audacity, my fourth grader, to tell his teacher that my dog ate my homework. He blamed him not doing his homework on the dog. That doesn't fly in my household. That doesn't fly in any school classroom. That doesn't fly anywhere. But effectively in that moment, I referenced my fourth grader, and we had a great lesson learning moment through that. But I referenced to the jury that my fourth grader was no different than what that 60-year-old corporate defendant was doing. He was telling the jury the deer caused the accident. I couldn't have driven any safer. It was the deer. He blamed the deer. The jury was upset. The jury was out for not long at all, maybe a couple hours. And they came back. Our client had a few $100,000 in medical bills. Jury came back at $5 million verdict. Unbelievable. Historical, great verdict in Fulton County at the time. And so we had an opportunity to talk to some of the jurors after this trial was over. And the jury was very, very boisterous about their thoughts. Some of them said, Mr. Smith, we wanted to give you guys more. We wanted to give your team more. Some of the jury said, we thought that was a great number, $5 million for this case. And we said, why did y'all give such a big verdict in this case? And they said it was the obstinance of the defendant. In other words, had the defendant just said, yes, I messed up and I'm so sorry, the jury probably would have awarded a lower number. But the fact that they dug in, they drank the Kool-Aid as to blaming the deer, doesn't work in fourth grade, doesn't work in real life. The jury came back for a number that we were all surprised about. We were shocked. $5 million jury verdict. So that was a great memory, a great trial. We had a phenomenal client. And of course, the client who's just gone through a week of trial was relieved. And there was a peace that comes with having that closure. The closure that this was finished. You all saw it all the way through, and that's what we do. So that was a great result, one of my favorites, and fits perfectly in our verdicts and victories time together.